They said, the judge, if you see Trump moving any of these people out, you just let me know. I'll come in and stop it. They didn't even respond to him. Trump appealed all that, said, you guys need to file this in habeas. Then the Supreme Court vacated Boasberg, said you have no power. They should have filed in Texas. What is the form? Are they getting a sticky note? Like, do they just get like a 3x5 card? Someone slips it through there, says bye-bye. They go, hey, it says so. Is that what's happening? President Trump and the DOJ now responding to the Supreme Court case that was stopping and staying the deportations. We remember that the ACLU gangbang lawyers brought this case on behalf of AARP. This is a person, not the AARP, American Association of Retired People, but it is a person who is a non-citizen who is suing Trump. We know the Supreme Court got this case, acted on it in the middle of the night, issued a stay certifying a putative class of gangbangers and saying Trump can't deport any of these people, and said, submit your response as soon as we know what the Fifth Circuit wants to do on this. Now, the Fifth Circuit denied the gangbangers' appeal, and so D. John Sauer, you know who he is, you'd recognize his voice anywhere, says, in response, please accept our filing. This is going to the Supreme Court of the United States. D. John Sauer says, all right, listen, SCOTUS, we are responding to the gangbangers who submitted an emergency application to stop us from deporting people. Here's what we say. We are respectfully submitting this to oppose them. Late yesterday, they came to the Supreme Court and they sought an unprecedented injunction from this court against the removals of any members of a putative class of aliens who are or will be detained in the Northern District of Texas pursuant to the Alien Enemies Act. Now, those aliens are Venezuelan nationals who are unlawfully present in the United States, and they're subject to removal under other authorities as well, but who the government has determined are members of foreign terrorist organizations called Tren de Aragua, and thus they're subject to removal pursuant to the Alien Enemies Act. This court should deny their request to stop us from getting rid of these people. Telling the Supreme Court, to start, you know, the Supreme Court, you guys are a court of review, not first view. But the application here from the gangbangers insists on judicial review in reverse. Oh, it calls for the Supreme Court to be the first to resolve so-called due process challenges to the adequacy of notice that designated alien enemies receive, right? And this is literally what's on the form. What do the boxes say? What can you check? Is it in Spanish? Is it in multiple different languages and more? Do they get a reading light? Do they get reading glasses? Do they get a leather chair to read it in? Are you giving them an espresso so they're properly caffeinated to review their illegal status? If not, make sure their gangbang lawyers bring them one. On behalf of a class that's not even existent, you say that there's a putative class? The lower court didn't even certify them. Now, as the Fifth Circuit observed, appellate courts should not address those questions unless and until the lower level district court has given a reasonable opportunity to do so. They said, the judge, if you see Trump moving any of these people out, you just let me know. I'll come in and stop it. They didn't even respond to him. They did, and they said, you have 45 minutes to do something about it. 42, actually. And he didn't, so then they appealed it. Yet the applicants gave the district court a mere 42 minutes notice before divesting it of jurisdiction. Sorry, judge. Thanks for denying our claim. We're now going to appeal it. Trump writes to the Supreme Court saying, under these highly irregular circumstances, they can hardly establish a clear and indisputable entitlement to the extraordinary relief that they seek. This should be denied on that basis alone. Now, in addition to the prematurity noted by the Fifth Circuit, fatal weaknesses in their claims foreclose any possibility of relief for them. Their counsel filed an emergency application on behalf of clients whom they don't even represent, putative members of an uncertified class using a procedural vehicle that is unavailable and uniquely unsuitable, which is a class-wide adjudication of habeas claims, right? You get to file a habeas petition on behalf of everybody to challenge their status. How are you going to do that? Because what if one guy's a gangbanger and the other guy's not? Or one guy has some other, status or some other, every person is unique. So you can't certify them all in a class, saying it's totally inadequate. And they're trying to do that to stop us from removing people under the Alien Enemies Act. They're doing so by leveraging a non-representative class members. They're even denying being members of Tren de Aragua, right? It's people who say, I'm not Tren. And they're saying, oh, you're not? Well, we're going to certify everybody who also is Tren. And you're supposed to have commonality. You're supposed to be the same. That's why it's a class action. We all got impacted by lead and paint or whatever, right? And you get to sue together. But in Tren, they're all arguing we're not Tren. Okay, well, the proclamation only applies to the people who are Tren. So file your habeas petition, show us that you're not Tren, and we'll let you go. Also ignoring class-wide differences as well. Now, given these deficiencies, applicants cannot show a clear and indisputable entitlement to relief. Trump says to SCOTUS. Now, they dismiss these problems. They speculate. They say the AEA detainees will be removed imminently before their claims can be further tested. But they ignore that the government has has provided advance notice to these detainees, included to the people who are in this lawsuit before we even ever began the removals, right? And so to be clear, that is due process, right? That is notice. Notice is a component of due process. Detainees receiving such notices have adequate time to file their habeas claims. Indeed, the putative class representatives and others are filing the claims, right? You guys are suing. This is a point we keep making here. You have plenty of time to sue. You're in court. Nobody's gone. It worked exactly as planned. So just do that. You guys know how to do it. You can clearly do it. You don't need 30 days. You're in court right now. So just do what you did the last time. And the government has agreed not to remove, pursuant to the AEA, those who do file the habeas claims. So no one's getting removed who is challenging it properly. This court should dissolve its current administrative stay that was issued by apparently 7 judges, including Gorsuch and Kavanaugh. Wild. But maybe they were asleep. Who the hell knows? To address the relevant legal and factual questions in the first instance. They'll wake up groggy like, oh man, I took, one extra Ambien that night. Shouldn't have done that. Waking up, what? Injunction for who? Sure. Stay everything. Whatever you say, Amy. I got to go back to bed. I can't even see straight. So the court should limit the administrative stay to removals pursuant to the Alien Enemies Act and leave undisturbed our ability to remove these people. Here's why. Now, the president issued a proclamation. They say the president issued this proclamation calling Tren de Aragua transnational criminal organization that originated in Venezuela and done a bunch of things. Conducted kidnappings, extorted businesses, bribed public officials, authorized its members to attack and eliminate U.S. law enforcement, and to eliminate a political figure in Venezuela. TDA has been designated a foreign terrorist organization by the Secretary of State. Now, that designation reflects the Secretary's finding that TDA engages in terroristic activity and terrorism. It retains the capability and threatens the United States and national security of the United States. On March 14th, the president signed the proclamation, which was published on March 15th, invoking authorities, saying, these are terrorists. A predatory incursion has happened. The provision elaborated on related powers, including the power to direct the conduct toward the aliens and to remove them. The March 14th proclamation outlines his findings. Trump writes to SCOTUS that the TDA members meet the criteria for removal under the AEA. These findings are undisputed here. The president found that TDA is doing the following: conducting irregular warfare, undertaking hostile actions against the United States. Yeah, just ask anybody who's lost a kid to them. The president additionally found that the TDA and other criminal organizations have taken over the Venezuelan territory, resulting in a hybrid criminal state. Yeah, how many teens or dead women in the United States as a result of gangbangers from foreign invaders in our country versus like the Russians, for example? Moreover, TDA is closely aligned with Maduro's regime in Venezuela and has infiltrated the regime and military and law enforcement apparatus, right? So they'll respond, right? So Trump is now making the connection under the AEA. This is kind of a government, right? This is a governmental thing. They're going to come back and say, no, that's not true. Those facts are not true at all. Based on those findings, the president proclaimed that all Venezuelan citizens 14 years of age or older who are part of TDA are within the United States are alien enemies, and they remain deportable under the authorities under Title 8 as members of a foreign terrorist organization or otherwise. And here's the U.S. Code citing that. So once it's labeled, boom. Now, the J.G.G. case. On March 15th, 5 Venezuelans, this is the Boasberg case, detained at an immigration detention center in Texas, sued in D.C. Okay, they were in Texas. They sued in D.C. in Boasberg because they're forum shopping for their BFF Jeb. The detainees moved to certify a class of all non-citizens. Boasberg granted it. They initially sought habeas relief there until Boasberg said, yeah, you got to drop that claim. Otherwise, I got to dump your case. You got to go take that to Texas. The same day, the district court, just like this court did, the Supreme Court, in issuing these immediate stays, issued TROs saying, don't remove anybody. And then, of course, Trump appealed all that, said, you guys need to file this in habeas. Then the Supreme Court vacated Boasberg. We read it here. Said, you have no power. They should have filed in Texas. The court recognized in that the Alien Enemies Act largely precludes judicial review. Okay, if the judge was the person who got to decide and say, well, Tren de Aragua was actually not alien enemies, or MS-13's not really alien enemies, then that judge might as well be president. We didn't elect the judge to make that subjective determination. Trump made that determination. Joe Biden and Democrats, their political position was MS-13, I think it still is, they're national heroes who are better than you. And moms in their states who've lost someone to illegals, they're better than you. That's why they spend all their time going down there and loving them up, fighting for them versus fighting for you. And it's like what they're saying. So if that's their position and the American people reject that position, Trump comes in and he says, here's my position. I identify a threat because I have eyes and ears and a brain that functions, and I'm going to use the law to execute what the American people elected me to do. Pretty basic. If a judge can come in and substitute his decision for that and say, actually, that's not really what that's for. Actually, we think that you're doing something something racist, or there should be more due process, whatever, and comes up with basically a violation of the law to substitute his judgment in, that's a violation of that judge's power. They're acting outside of the law. Now, they may have a bunch of plausible justifications for doing that, right? To say, well, no, due process and Fifth Amendment, APA, and all this crap. But we know ultimately what they're doing. And the Supreme Court is coming down and admitting, right, this is why they're highlighting this, largely precludes judicial review. Congress said, you can't review this stuff because of that problem. But the court then, Trump says, held that an alien detained under the AEA is guaranteed limited judicial review as to questions of interpretation and constitutionality of the act, as well as to whether he or she is in fact an alien enemy, subject to detention and removal under the statute. The court agreed with the government that such review must be brought in habeas, in the district of confinement, okay? So if somebody wants to go and challenge and say, whoa, 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 I am not Tren de Aragua, no problem. Go file it in habeas in Texas on your own. You get to go file it. There's your judicial review. Go enjoy it. Now, again, subject saying, well, what about the interpretation of the act? The act says it's Tren de Aragua, and somebody's like, well, I'm not really Tren de Aragua. I'm kind of something else. Well, how does the act apply to you? How does the proclamation apply to you? It's for you, not for a class of everybody. The court then, now because the detainees had brought the wrong claims in the wrong court, oops, the district court lacked authority to issue the TROs. The Supreme Court said that. Judge Boasberg's injunctions were vacated. Now, the Supreme Court, they write to the Supreme Court, hey, reminder, you guys said this. You said must be brought in habeas, quoting you. You said it is largely precluding judicial review. You just said that like a week ago. This court further clarified that as, quote, as a matter of due process, Alien Enemy Act detainees must receive notice after the date of this order that they're subject to removal under the act. And so in keeping with the context of the nature of due process, it's context sensitive, the court did not mandate any specific notice procedure. Because what's the court going to say? What if you need to get a terrorist out of your country in 5 minutes? That's a special dip. The president has that power to do that. Can the court stop that and say no, only after he's got 30 days to consult with the ACLU? Instead, the court stated the notice must be afforded within a reasonable time, kind of dependent on the circumstances, who it is, what the reason is, in such a manner that will allow them to actually seek habeas relief in the proper venue before removal occurs. Allow them to, okay? It's not mandatory that they get it. If they want to seek it, they can get it. They're not mandated to have a hearing. Quoting the Supreme Court, that's from them. Now, following the court's decision in Boasberg J.G.G case, numerous detainees have brought habeas petitions. They know how to do it. Great. Courts are adjudicating those claims. Great. Citing a bunch of them. See, look, they know how to do it. It's not that complicated. So you don't need a class-wide stay. Now, applicants don't dispute the government is not removing them. If they file habeas, like it always should have been, then they can stay. Indeed, the government has done so for the class of representatives here, though removal pursuant to other authorities like other Title VIII laws remains available, okay? Like, we're not going to remove any of these people, but we could. We don't even need to use the Alien Enemies Act, but we could remove them regardless of that. But because you issued a stay, we'll just hang on to them. They write, on April 16th, not long ago, applicants AARP and the others filed a petition for a writ of habeas corpus in Texas, which is the right place to file. They contended the proclamation of Trump is inconsistent with the statutory requirements of the AEA and is insufficient notice and opportunity for review. They then filed an emergency TRO stopping their removal, and they also filed a motion to certify the class. Now, on April 17th, Texas denied them. The court explained the government had unequivocally, Trump said, no, we're not removing the people. You're here, like, don't remove them. They said they're not removing them. The court thus found that they're not in imminent risk of summary removal at all, and the court reserved the decision on the class, but then they appealed. They filed a second motion claiming, hey, they're going to move them any minute. Now, the district court has since explained, saying they were acting with the utmost speed to resolve these things, but they're important and they're complex. And the judge said, we were prepared to issue an order. As soon as we got the government's brief, we would have gotten you a response by Saturday, for crying out loud, but it wasn't fast enough. Without waiting for the government to even file its opposition brief, and after giving the district court just 42 minutes to rule, they went to the Fifth Circuit and then they went to the Supreme Court. Back to back. They treated the district court's failure to respond to them and grant their relief within 42 minutes as constructive denial. And early this morning, the Supreme Court then entered an order inviting the Solicitor General to respond. We are now. You directed the government not to remove anybody until then. Fine, we haven't. Now, the Fifth Circuit has denied their motion as premature. They said that if they were concerned about the government, like not removing people, you should have litigated that down with the lower court judge. Instead, you gave him 42 minutes to act. Then you went up to the Supreme Court and you got a nationwide or at least a district-wide stay. In her concurrence, Judge Ramirez explained that we don't even have jurisdiction to address any of that. And so we cannot find a denial when there was no denial. You just demanded a response within 42 minutes. You're like one of those, like, psycho exes. Like, where are you? I said respond. Are you there? And then you get the long one. You know how you you've done this to me so many times in my life. I can't believe it. Like, all right, that's it. We're out of here. So applicants must surmount a particularly high bar. They asked this court for an injunction or alternatively for mandamus relief, both of which require establishing a clear and undisputed right to relief. The court's injunctive power is to be used sparingly and only in the most critical and existent circumstances. Here, their right to relief must be indisputably clear. Like if we're going to issue this stay, it's got to be absolutely clear. Here, they have not made an indisputably clear showing about anything to secure an extraordinary relief that they're seeking. As the lower level court, the Fifth Circuit, held, applicants' request is fatally premature because they improperly skipped over the lower courts before asking the Supreme Court for relief. Moreover, because the government has committed to not removing the named petitioners pursuant to the AEA until their habeas proceedings have concluded, they're seeking relief on behalf of non-parties, okay? Putative members of an uncertified class that cannot be certified in this context without flouting the rules. And so this court should deny the application. And this is fatally premature. Both lower courts in this case have recognized this. Supreme Court, you're a court of review, okay? Not first view. Yet no court has yet passed on their claims that the government's notice proceedings have been inadequate under the due process clause. And again, like, what is the form? Are they getting a sticky note? Like, do they just get like a 3x5 card? Someone slips it through there. It says, bye-bye. They go, hey, es eso. Is that what's happening? Or is there more notice on that? Does it say, hey, you're about to be afuera out of our country. Here's why. Here's the notice. Like, that's what it is. Applicants gave the district court only 42 minutes to rule on their motion before immediately proceeding to the Court of Appeals, thus divesting the district court of jurisdiction. Now maneuvering left the lower court unable to do anything. I don't have jurisdiction anymore. What do you want me to do? So then their premature filings also left the Court of Appeals without jurisdiction to act as well. As Judge Ramirez explained, says we can't act. There was no actual final order there. And so it's procedurally improper, so you're denied. So this court, Supreme Court, should also deny that. The lower court should resolve this. The lower courts have not found critical facts in this case at all. Our notice is fine. There's plenty of forms on there. It's in English. They got it. There has been no fact finding about the timing, the nature, the manner of the notice that the government has been given to these people. It's a beautiful form. Nor has there been any fact finding in the lower courts about which detainees in the class have actually tried to seek habeas and whether any detainees were deprived of that opportunity at all. Just file. And likewise, no court has passed on the legal adequacy of the government's notice procedures, nor has the chance been given to the government to defend them. So this court should not make those determinations in this first instance. You should deny this petition, allow the lower courts to proceed. Now that approach will not cause them any harm, okay? The government has agreed. We're not removing these people while their habeas petitions are pending. The named petitioners thus will not be prejudiced by litigating their cases through normal federal litigation. And their requests are defective. They can't show irreparable harm to them. They're trying to act on behalf of a bunch of detainees in Texas. But under Article 3, their remedy must be limited to providing relief to the injured parties. No class has been certified here. This putative class thing, they're not parties to the dispute. It's not an actual class. So this court lacks authority to grant relief to them, and you can't stay their removal. Underscoring the impropriety of leveraging a proposed class to obtain broad relief, this is manifestly improper. As a general matter, the limited habeas review available in the AEA cannot be pursued in a class action. All right. As the government explained in the other case, the determination, the Boasberg case, whether individual AEA detainees are entitled to habeas relief is inherently too individualized for class-wide relief. Each person needs to be reviewed independently. The determination whether a particular detainee is a member of TDA or otherwise is individual. It precludes commonality. Everyone's going to say, I'm not a gangbanger, but we're saying you are, right? So you're trying to like extricate yourself from the class. So how is that a class with commonality? It's not. Moreover, it is effectively impossible to define a class for which a member could be an adequate or typical representative or any class of individuals subject to the proclamation. It covers only TDA members, but the petitioners in habeas disputes dispute their membership. And so the class action mechanism is improper for applicants' claims about notice and due process. Applicants seek class-wide relief on behalf of all non-citizens in Texas. The class as defined includes too much variation to satisfy the rules. To begin with, the proclamation only applies to Tren, but applicants themselves dispute that they are Tren. So it's not, the class has to be representative. So the people who are in the class of people affected by this, there's no commonality there. They're not actually representative. And moreover, to the extent the common allegation is that class members all have suffered a due process violation, is what they're saying. No, it's not. It's all the people who are being abused is who we're identifying. That is insufficient to satisfy commonality, right? You got to have something more than that. The allegation is deficient because due process is flexible, says this other case law from 1976. Indeed, this court has recognized that class action may not be the proper vehicle to resolve due process claims at all. And here, although Trump and the government maintains that the notice that was given to these people was adequate, it, individualized factors, including their language ability, their family existing, and their relationship with a lawyer, may be relevant to determination about what notice is. What is good notice, what's not. Now, their proposed class definition also encompasses individuals who may have no claim to additional notice at all, because they're not even going to challenge their membership. They're not going to file their habeas claims at all. There might be people who've waived this. We can't remove them. The very fact that applicants filed habeas petitions, but others did not, illustrate these differences, right? Some people are not going to fight it. They're just like, all right, just send me home. I'm out. The problems do not end there. The rule states that an injunctive class may be certified if the injunctive relief is appropriate to the whole class. But whether an alien is a member of TREN, whether he has been given sufficient process, whether he's removable under a different provision of the law, or other such questions are individual. You can't have a class action for them. They're not all acting the same. Some people might be TREN, some people might not. As this court has explained, the rules don't authorize class actions when different people are entitled to different outcomes. But they ignore all of this. They don't address the disparities in the class. They claim that class treatment is preferred because there's vulnerabilities to them. But this court has never suggested, however, that there's some sort of exception to the rules for vulnerable classes. Like, where'd that come from? So you can't certify that. Now, at minimum, if this court keeps its administrative stay in place right now, the government respectfully requests that the court clarify that it is administratively staying removals only under the AEA. We have other powers to remove these people. We can use them. And say that the order does not preclude removal pursuant to other immigration authorities. Putative class members may be independently removed if they're members of foreign terrorist organizations or otherwise. Here's some other section of the law. Applicants do not purport to challenge the removal under any other authority. They're just upset with the AEA proclamation. So clarification is warranted because we're going to continue to conduct our lawful and unchallenged removals under Title VIII. And so at minimum, this court should deny the application. And if you're not going to do that, at minimum, clarify that its administrative order does not preclude the government from removing detainees under the Alien Enemies Act submitted by D. John Sauer, the Solicitor General. And so we'll see what the Supreme Court does next with this. Of course, we'll be waiting for them to issue an update and give us some more deadlines. But that is the latest from Trump in the Supreme Court, wanting to have the Supreme Court vacate their stay so that the deportations can continue. Thanks for subscribing and joining us. We do. As soon as the Supreme Court issues a ruling, we'll be here and we'll be covering it.